So as we apply the ethical theories, let's look at the three most common ones: the utilitarian argument, the rights-based argument, or the universalist argument, and the justice argument. And in all those circumstances, they make a really good case for why job discrimination is immoral, is unethical. Number one, utilitarian arguments claim that discrimination leads to an inefficient use of human resources. That when we are hiring people, we are not hiring people who may be the best person for the job. We end up with having inefficiencies in the way that people are utilized in the workplace. The rights-based approach is looking at the basic moral rights, and we are treating people without dignity. We are treating them not with the categorical imperative of how we would like to be treated consistently across situations. And so that becomes inappropriate either. And then the justice space, which we'll get into in the next slide. But the justice space is looking at the level playing field and what is fair. And if we have inequalities, are they lifting up the least advantaged individuals? And when we are discriminating, we're not doing that. And you can see from the justice and fairness perspectives from all of those slides about income inequality and workplace inequalities and pay and benefits, we definitely see that there are significant differences between men versus women and majority groups versus minority groups in terms of racial ethnic issues. We won't even get into things like discrimination and sexual orientation. I mean, these are just based on gender and sex, gender and race, and we see those significant differences. And again, as I said, the justice-based arguments say there is an unjust distribution of benefits and burdens. And we already discussed this in the previous slide, as well as in the previous part 3, where we saw all of those graphs and data points to support that argument. So what kind of discriminatory practices where do we typically see these problems? We see this, number one, in recruiting, where we will only recruit via word of mouth, or we only recruit people who look like us, think like us. Recruiting from the same school results in that problem. So if you always recruit from one particular school, you're not diversifying the perspectives and the points of view by having people come from different schools or different educational backgrounds. When we screen resumes, as I already said, we saw that happen with the unconscious bias. That happened in my study, where we looked at men versus women and had the same exact resume, but the men were always evaluated as being more qualified. And again, when we are screening, and if unconscious bias is entering into that practice, we see that as a major problem. Promotional opportunities are looking at how people perceive individuals and who gets the opportunities to be developed, and also then that follows who gets then the opportunity for the promotion. Because if you are not getting the opportunities for development, you are not going to be qualified for the promotion. So it's a system that keeps perpetuating, keeping other groups down and disadvantaged in that situation. Conditions of employment like pay and benefits and things like that. We should see things to be the same, but again, we see salaries are different for women and minority groups. And opportunities, I think, for certain kinds of benefits, we see the same thing. And then discharges, we're far more likely to see discharges based on race, gender, sexual orientation, gender identity than we do for majority groups. In terms of sexual harassment is a form of sex discrimination, and it's looking at how we create an environment where unwanted sexual advances are considered necessary for promotional opportunities or hiring opportunities. And also it can create what we call a hostile working environment, where there's an environment that's sexually charged that makes people feel uncomfortable when they work there. And again, it's an example of how these behaviors are an example of a lack of justice or fairness, a form of discrimination that is not moral. We treat people inappropriately. We sexualize them in the workplace in such a way that they feel like they cannot comfortably do their job. EEOC differentiates between quid pro quo, which is have sex with me and then I will give you a promotional opportunity, as compared to a hostile working environment, which basically means that there is a sexually charged environment that is hostile to people who don't buy into that perspective, that is offensive and it feels offensive and abusive to the employee. One of the hardest cases to determine is what is considered a hostile working environment, because it is all about perceptions and about what I perceive to be hostile versus what you perceive to be hostile. But we have seen in cases like Mitsubishi Motor Company here in Illinois, where some of the women at the organization said the behaviors of the men were sexually harassing and made them uncomfortable, but other women did not believe it was sexually harassing and uncomfortable. And so that was the argument. It's like, if we don't think it's harassing, then you shouldn't either. And what the company had to realize is, even if one person said makes me uncomfortable, we have to set the tone for the organization so that it is a place where everybody feels comfortable to be able to do their job. And it's complex figuring out what is intentional, how much responsibility the employer has, what effect does a hostile environment have on people. It can cost you a tremendous amount of money. We know this, and it does make it very difficult for people to feel comfortable working on the job if everything feels very hostile to them and very explicitly sexual, because there's no place for sexuality like that in the workplace. We're here to do a job. We're not here to talk about sex or to engage in sexual behaviors. That doesn't mean that people don't do it behind the scenes. Like, that's not anybody's business. But in the job, in the workplace, in someone's face, that's a much more challenging situation to be in. Lastly, we have to recognize that it isn't just, as I said, race and sex where we start to see a discrimination. We can see it based on age. We see it based on ability status, whether or not you have a disability or are perceived to have a disability, your sexual orientation, your gender identity status, how heavy you are, and your obesity levels. There are no protections for obesity, although there are protections for sexual orientation and transgender based on Title VII. But those are very limited right now until we get some clarity with laws from Congress stating very specifically what is protected. But age and disability are definitely protected. Orientation and transgender status, gender identity, it is protected, but not extensively with lots of guidelines. And then obesity, of course, is really not protected unless it is considered morbidly obese, which is considered a disability, in which case then certain things, you still have to be able to perform the essential functions of the job. But I can't treat you differently and give you different benefits. If you can do the job, I can't treat you differently and give you different benefits because you are morbidly obese. These last few slides deal with affirmative action specifically. And it is important that we recognize that affirmative action is not a law, but actually is an executive order. And that executive order argues that we need to make sure that we are doing what we can to remedy imbalances and historical persistent underrepresentation of women and minorities in all sorts of situations, particularly in the workplace. Even though the Supreme Court weighed in, the cases in the beginning of this lecture weighed in on affirmative action in higher education, it really is in the realm of employment, workplace situations, and basically tells people you must make a good faith effort to attract qualified women and minorities. People who are government contractors with certain requirements financially, in terms of the dollar value of their contracts, are mandatorily required to do affirmative action. And then there are people can do it because they're court ordered to do it, because they have significant persistent discrimination that has gone on historically. And then people can do it voluntarily. And I think people don't typically have an issue with the government contractors and then the legal issues, but people struggle with the voluntary. I think that creates more discomfort for people. I disagree. I think it's just as good and it's just as important as anybody else, but I can understand why that feels more uncomfortable for some people than others. But ultimately, affirmative action requires us to make a good faith effort to attract qualified women and minorities and prepare qualified individuals for opportunities for advancement in the organization. And so we do a utilization analysis where we compare, the local market to our company, and we compare, all those levels to make sure that we are properly representing what should be available to us in the marketplace. And so if we are really underrepresented, for example, in an area where it's predominantly Black populated and we have very few Black people working for us in our company, this is an illustration that we've got an issue that needs to be addressed. So we should be hiring qualified local people for positions. An executive order, just so you're clear, is different from a law. A law is signed into being from Congress, whereas an executive order is much more focused on the president writing an order about what happens with government contractors and things like that. So the Supreme Court has basically addressed some aspects of affirmative action, but it hasn't fully fleshed it out. I mean, even how many years later this was passed in 64 or 65, and we still are struggling over what it means to do affirmative action, mostly because there's a lot of misinformation out there about what the executive order actually requires. But the biggest complaint, as we talked about earlier, is that it feels like there is what we call reverse discrimination, and that in and of itself it is discriminatory. And I can understand if people have misinterpreted what affirmative action is, that would be grounds for a misinterpretation and a form of discrimination. The executive order requires us to make a good faith effort to try to attract qualified women and minorities. And that is the beginning and the end. Another argument that's been made for why affirmative action is not good for us is that affirmative action has actually harmed those where that they've tried to help. And I think that if we are misapplying and misusing the executive order, I can see that as a real issue. But if we are doing this in such a way to make sure everybody gets equal opportunities, then I think that we can see how affirmative action can be beneficial. Here's what we know. When we look at the glass ceiling report, the glass ceiling report told us that those companies that were most successful in combating the glass ceiling in their industries, those were companies that made sure there were equal opportunities for everybody in the company. Not only doing affirmative action for women and minority groups who were struggling, but also for white males who may not come from they may come from a place of privilege or advantage because they are white males, but not necessarily based on their upbringing and their educational situations as well, because men also can live in disadvantaged situations. And so when we look at the person and let's say, what do you need help in to be better, to get more advantage, to be able to be the best you can be at your job? And when we help everybody, we get rid of the disparities. And that's really where we want to be at the end. Yes, when we are pointing out people and saying only these people are going to get help, it is discriminatory in both directions, and it creates harm for those who are getting quote unquote the advantage, because then they get held up to be as if they really weren't deserving of that opportunity. And that's not how we want people to feel. How do we apply the ethical theories? Well, let's look at utility analysis, or the utilitarian argument. And the utilitarian argument basically is that affirmative action claims reduces the need to benefit women and minorities in needs. So it actually increases utility by helping make sure we create that level playing field. From a justice perspective, as I said, we create the level playing field. Everybody can compete. There's justice and fairness in the system at play. And in this way, everybody gets an opportunity to be advanced into positions that are of value to them. Ultimately, the justice argument is looking to better distribute society's benefits and burdens. It's trying to neutralize unconscious and conscious bias. It's trying to neutralize competitive disadvantages, creating that level playing field so everybody can compete fairly. And overall, it wants a more just society. And so at the end of the day, we're implementing affirmative action and managing diversity in order to make sure that we see a better society for everyone. But obviously, there are opponents who believe that productivity and criterias other than race and sex and hiring are going to be infiltrated here. And really, the criteria should be, first of all, can everybody compete? And once they compete, then we can look at the criteria to ensure that it's fair for everybody across the board.